The Supreme Court is going to be taking on another case for veterans. It's regarding the benefit of doubt rules within the VA. And a lot of us have heard about these rules, about the fact that if evidence is equal on both sides, the VA is supposed to rule in your favor. And I believe that came out in 2002, where they kind of tightened that up a little bit to make it more clear that essentially if evidence is in equipoise, they're supposed to rule in your favor. Now, this is a big deal. The Supreme Court is to hear these cases next term. The next term for the Supreme Court is October of 2024, so the next federal fiscal year. And we could see some big changes coming from this decision. Either it's going to tighten up that benefit of doubt rule, or it's going to push it out a little bit and make it a little more, easier to access claimed benefits through that rule. Now, let's be honest. The vast majority of us did not document all of our signs and symptoms and illnesses and injuries while we were in service. It was frowned upon. Rub some dirt on it, move forward, eat some Motrin, right? Drink water, change your socks. So I get it. It makes it really difficult to file your claim when you don't have hard evidence specifically regarding nexus, the link between your condition and your time in service. So when you think about how the VA works, what they really want to see is three things. They want to see that you served, right? Entry date, exit date. This gives you a window of opportunity. 2, they want to see that you have a diagnosed condition. 3, they want you to have a nexus. They are saying, prove to us, the VA, that your condition manifested during your time in service or is a result of your time in service. Prove to us one of those things. Now, many of us have a hard time doing that. We either need to show that our condition started during our time in service or as a result. Now, a situation of, I'm going to give 2 examples here because it's relevant to this Supreme Court case. There's 2 examples that I'm going to give. One is I'm going to show that the VA that my condition manifested during service, but I don't have anything in my record. So I'm going to have to, for my migraines, we'll say. I have migraines, started getting them since I was in service. I have to now manufacture evidence. I need to reach out to people that I may have served with, maybe shared a room with or whatever, and that could basically write a letter for me attesting to their knowledge of me having migraines and they saw me eating handfuls of Motrin or whatever, right? So you'd get 2 or 3 buddy statements, if you could, from people that you served with during that time frame that could attest to knowing you had migraines. Then you would also want to, in my opinion, leverage your family. So this would give you the prior to service aspect. A mother, a father, a brother, sister, whatever, basically attesting to, before he joined the military or she joined the military, never had migraines, never knew them to have any sort of issues like that at all. And it wasn't until after they joined that I noticed that they started to have migraines. So now you have no migraines before, migraines during. Then you'd want to then leverage your doctor to go ahead and write down a nexus letter. Now, you're going to hear from not just me, but a lot of folks. Ideally, your doctor would say that your migraines are most likely manifested during your time in service or due to your time in service or started during your time in service or whatever the right verbiage is. But you'll hear a lot of us say the minimum threshold is it's at least likely as not that your migraines have manifested during your time in service, because that's what the VA's threshold is. If they're not sure on something, like, well, it's a coin flip, 50-50, we have to rule in the veteran's favor. Great. So that's how you're setting up your migraines one. Now, let's say that it's something after the fact, after you got out of service, right? So you get out of service, and let's say that you come down with an illness that's associated with Agent Orange. and then you look back and you see that you served at a specific base that utilized Agent Orange, stored it, used it, tested it at your location, but it's not a presumptive location. But you know that they used Agent Orange there. If you can find anything in your favor pointing to the usage of Agent Orange at that base, the chemicals found in it, any traces of it, anything that you can use, a news article from back when you were there or what have you, anything that can show. For example, I just recently did a video on Fort Ord in California where they have not an overwhelming amount. The military's not conceding to the usage of Agent Orange, but there were news articles, there were publications, there was a Army Corps of Engineers, in fact, did a study there in, I believe it was 1994 or 5, right around the time the base closed, and they found significant traces of chemicals that are used in Agent Orange. So you put all of those things together and it becomes very likely that Agent Orange was used there. So if you have a condition that's associated with Agent Orange and you served in a base like that, and you can dig up some documents, local news articles, anything that's talking about the usage there, any sort of reports, anything that can basically justify your position that Agent Orange was used there, then now you have something to file. I have a condition that's associated with Agent Orange. I served at this specific location, and I have this documentation that says that Agent Orange was used there. So you combine all of that, you file your claim. Well, now the VA is going to look at is it likely or not? Is it at least likely as not? Is the evidence in equipoise for and against? And they're going to read that. So those are two examples on where the VA has to make a decision, right? It's not clear cut. There's some, I guess, nuance to it to where the VA has to decide whether or not this is in fact service connectable. And again, there is the rule that says that if the evidence is equal, they're supposed to rule in your favor as a benefit of doubt. So this Supreme Court case is exactly that. I did a video on this earlier. I'm just going to do another one. I'm just going to read through it here because I just want to make sure that this information gets out. So I'm just going to read it quickly here. The Supreme Court on Monday added cases to its calendar for the term beginning in October that deals with veterans' benefits in a case that could have significant implications for those who serve in the military. The Supreme Court will weigh a matter involving two veterans who argue they were improperly denied medical benefits for treatment of post-traumatic stress disorder related to their service. Joshua Bufkin, who served in the Air Force from 2005 to 2006, and Norman Thornton, who served in the Army on active duty from 1988 to 1991, say they should get care under a benefit of the doubt rule that requires the Department of Veterans Affairs to provide access to treatment when it is a close call whether the applicant qualifies. Both cases had evidence for and against them receiving benefits. The U.S. Court of Appeals for Veterans Claims denied their appeal for benefits, saying there was no error in applying the benefit of doubt rule. Now, remember that as you go through the disagreeing process with the VA, you could file your claim, they deny you. File a higher level review, deny you. File supplemental claim with additional evidence, they deny you. Push it to the the Board of Veterans Appeals, the BVA, push it there, they deny you. You can then push it to the U.S. Court of Appeals for Veterans Claims. So the Court of Appeals for Veterans Claims denied that appeal. When that decision was reviewed by the U.S. Circuit Court of Appeals for the Federal Circuit, the plaintiffs said the Court of Appeals ignored the 2002 law bolstering the Veterans Claims Court enforcement of the benefit of doubt rule that could have cleared the way for them to get care. The Supreme Court will review the court case the Court of Appeals interpretation of the 2002 law. So that is going to be very, very instrumental. And look, in certain situations, I mean, let's just use PTSD for an example. At PTSD, if they are denying you and you are in a severe situation, and let's say you have two dependents, a spouse and a child, that's $4,100 per month that you would be losing out on if they're denying you. And let the years click by, right? Let somebody, these people are lucky that if it gets overturned and ruled in their favor, they're lucky they pushed it all the way this far. Many people give up, especially once it gets to the Board of Veterans Appeals. They just throw their hands and walk away. Well, once the time frames pass, you lose out on your effective date, which could effectively potentially cost you, $250,000, $250,000 in your pocket, tax-free money that you would have had given the circumstances. I got a little spider right there. All right, that was fun. So it's just important that you preserve your effective date, push through, and in this case, I'm curious to see where the Supreme Court is going to rule on this. Are they going to, if they rule against it, it tightens up that benefit of the doubt aspect. If they rule in favor, it's going to loosen it up a little bit. Not dramatically, but enough to where we could get more vets qualified again, because we don't go to the doctor and document things while we're in service. With that, thank you so much for watching. I appreciate you. Have a great one. And remember, if we don't take care of each other, something went wrong.